Hey, Simon, here we are, ready to talk about our top 5 upcoming events in trusts for the next year or so, all on our appropriately socially distanced Zoom call. Yep. You in your Lincoln's Inn type room, albeit in Cambridgeshire.
And you in your actual Lincoln's Inn room in Chambers.
Thank you very much. I have the view. Now, all the courts have been grappling with this problem of social distancing and remote hearings, and they've been particularly concerned about how to hold public hearings and maintain open justice, right from DJs in county courts all the way up to the Lord Chief Justice, which leads us straight on to a topic that has caught your attention, I know, anonymity of representative parties.
You're absolutely right, Fenner, because there is this ongoing tension which has played out in recent case law between open justice on the one hand and the need for confidentiality and privacy on the other in certain trust cases. And the law is remarkably unsettled. I'm sure many of those viewing this video will be aware of the recent case of MN and OP, which concerned anonymity of minor beneficiaries in a VTA case. But of course, that's quite a particular type of application. And what I have certainly been seeing recently is a lot more argumentation in, for example, trust cases, confidential hearings, so forth, where there has been argumentation about the extent to which involvement of parties should remain confidential. The classic case, of course, Fenner, and I know you're very involved in these sorts of applications as well, is Bedo hearings.
Yeah.
So
you say it's uncertain. I say there's absolutely no authority on it at all.
Yeah. You're absolutely right. The section on Lewin is remarkably brief on this. And the question really does just arise, is it appropriate for a representative beneficiary's involvement to be confidential or anonymous? And the courts have not yet given a definitive answer. As I say, it's argumentation which has been put forward, I'm aware, in a number of different cases. And we will wait to see whether we have a published judgment in due course. I'd say watch this space for the next 12 months.
Yeah, no, I agree with you there. The issue of anonymity and public access to justice is a very hot topic for the judges, even if for practitioners it seems pretty obvious. It's interesting for me because that reflects another area that I deal with on a regular basis, the use of confidential opinions by rep bens. And these are opinions by counsel dealing with approval of a compromise, why it's appropriate, or why a VTA application should be granted, or even why there's no opposal by a rep ben to, say, a summary judgment application. Now, I had hoped that the issue had been disposed of in 2018 when we got Chief Master Marsh to give a pretty positive approval to the process in a case called Unipart Group against UGC Pension Trustee.
I thought that had settled the law, Fenner. Am I wrong in thinking that? Is that what you're telling me?
Apparently, we are wrong in thinking that had settled the law, because the Chancery Guide still says, at paragraph 29.98, still says the position is currently unsettled.
Nice.
I think that probably the problem is that there's just Chief Master Marsh giving the judgment, not a judge. But we've got at least 2 pension cases and 1 major institutional trustee case being issued and heard within the next 12 months. Pension cases on approval of compromises, major institutional case on directions being unopposed, coming up in the next 12 months, almost certainly before a judge. Hopefully this will give us an answer that is definitive.
Absolutely, because it will save a lot of time than rather than having to argue this at day novo each time you're in court.
Letters to the court saying, please do this, blah, 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 blah. Really annoying. Now, that's all procedural. Slightly more substantive is a case actually on unrepresented parties. And it's our 3rd top event of the year. It's a blast from the past. It is Crociani.
that old hoary chestnut again.
Unbelievable. We had a 2016 case that went to the Privy Council in 2017. We now have a 2018 case that is coming back to the Privy Council in 2021. To misquote Oscar Wilde, to have 1 Privy Council case may be considered a misfortune. To have 2 really looks like carelessness. I mean, or alternatively, really good for the lawyers. I say no more.
I can't say that statement has ever applied to counsel, I don't think.
No, I suspect not. Appleby Trust Mauritius Limited against Crociani. Very quickly, you've got a mother who sets up 2 trusts for her 2 daughters, Christiana and Camilla, falls out with Christiana, persuades trustees to strip both trusts of their assets, put it in their hands, blah, blah, blah. Royal Court of Jersey says this was a breach of trust, must reconstitute both trusts, both Christiana, who's suing, and Camilla's trust, because Christiana has a theoretical interest and because Camilla's daughters have a theoretical interest. Royal Court of Justice says reconstitute both. Court of Appeal in Jersey says because Camilla acquiesced and because Camilla is basically the same as her children, doesn't have a formal litigation friend status, but as good as, they're not going to require reconstitution.
Okay.
Now, Privy Council has granted permission to appeal on 3 big questions. Number 1, unrepresented minors, can the court act at all?
Well, I can see why they granted permission on that. I mean, that could raise all sorts of difficult Article 6 and A1, P1 issues, for example.
Absolutely, something that's been coming up increasingly, particularly in family cases, but also more generally.
Yeah.
Number 2, can the parents' actions affect the children's position in a case like that?
Another big question, because it seems to me one could look at that either from a really big and sort of fuzzy perspective, as in general, when should that be possible? So, for example, in a very different context, a parent's occupation of a property, to what extent is that occupation by the child, and where is the boundary? Or it could be a very techie, very small and narrow issue.
Yeah, absolutely. You've got a wide, fuzzy, and a narrow technical issue, and that's also. Third question, how to exercise the discretion to set aside breaches of fiduciary duty. Now, the Privy Council could take a narrow point and say this is all to do with the particular statute provided under Jersey law. It's Article 47H of the Trust Jersey law. I suspect there'll be wider comments of application to general jurisdiction to set aside fiduciary breaches. We will find out when it comes up in front of Privy Council.
Absolutely. Well, staying for the moment in the Privy Council, Fenner, I think is the 4th case to look out for in our list. And that's the case of National Stadium Grenada Corporation and NH International Caribbean. The appeal's been heard, but judgment is awaited. And the reason I think it's an important case is because it raises a number of interesting issues concerning the circumstances in which a trust will arise over monies which are paid by one party A to B for a specified purpose, for example, such as a promise to pay those monies on to C. It also raises a number of issues related to equitable assignments of beneficial interests in those monies. And the reason why I say it's an interesting appellate case is because the highest courts haven't actually grappled with these issues for quite some time. In the context of equitable assignment, for example, some of the leading authorities are well and truly halfway through the 19th century, not even the 20th century.
I'm quite impressed you say some of the leading authorities. As far as I'm aware, all the leading authorities on equitable assignment of the 19th century.
That possibly wouldn't be putting the case too highly. Yes, you're right. Almost all of them are in the 19th century, and it certainly is time, I think, that the highest courts do look at this again. And it will be interesting to see just how the Privy Council grapples with those issues when judgment is ultimately handed down. As I say, watch this space. Yeah,
I mean, I'm particularly interested in that because of the third-party interests under quis-closed trust. We usually think of them as the settlor and the trustee, but what about the beneficiary in those circumstances?
Yeah,
fascinating stuff. You have a rarefied Privy Council practice. I have a much more mundane one. But for the mundane practice and for all of us, I think, the 5th topic this year is going to be the 5th Money Laundering Directive. It's amending 2019 Statutory Instrument Amendment to 2017 Money Laundering Regulations. Here's the big thing. Up to now, trusts have had to register if they pay tax in the UK. Yeah. They register with the Trust Registration Service, the TRS. What's changing between now and March 2022 is that all UK trusts have to register whether or not they pay tax.
All UK trusts?
All UK trusts. Now, there's a handful of carve-outs, the most important of which are co-ownership trusts, will trusts that are wound up within 2 years of death. And
because we all know will trusts have wound up within 2 years of death.
All my will trusts have been wound up within 2 years of death. I don't know what you're talking about, Simon. And existing trusts with less than £100 in value, but new trusts with £1 have to be registered. There is no carve-out for bare trusts. It was going to be that we all had to register these things by 2021, March 2021. STEP persuaded it, March 2022. We're all okay on that. 2 things happening in the next 12 months. Government's producing information on 2 topics. More information on A, how they're going to scrutinise who has a legitimate interest when they're asking for information. And B, they're going to produce more information about how they're going to protect beneficial interest information where it might endanger the beneficiary, so kidnapping risks. So oligarchs and their families are going to be interested in what happens on this topic over the next 12 months. And that's it from me.
Thank you, Fenner.
Thank you very much, Simon.